Ngalakin Khadijan Nyunga Boja.
Testing. Okay, that sounds okay. Can those people online hear me? Okay, good. So, untie this. Right. Yeah, it gets like that now, doesn't it? I'm like that as well.
It's really bad. It's really bad.
That's why I put this around my neck.
I can clip this anywhere, can't I? Yeah.
Yep.
Cool.
Well, testing. Okay, good. Alright, I think it's 2 o'clock. Fewer people than I expected. Six online, 4 here. Okay. All right. Good afternoon, everyone. Today we have Albert Faroloro, who is a principal at Raise, attending here to give a guest lecture regarding intellectual property. Now, it's something we haven't covered in detail, but whenever you're doing design work, it is something that needs to stay in the back of your mind, even from the start, to see what your organisation, company can develop as intellectual property, and how that can be leveraged for the benefit of the company. So I won't be here for much longer. I'm just going to hand over to Albert to continue. Really appreciate you coming down, Albert. The floor's yours.
Thanks, DeLucia, and thanks everyone in person and online. Good to be back. A lot less graffiti than when I used to be here in my own times. So I'm going to give you a whirlwind tour of the land of IP. Try not to make it too boring because IP can be a pretty dry topic. So there's some slides in there that will hopefully keep your attention. And if you watch carefully, you might even see Miss Australia at some point make an appearance. Are we live again? Might just need to put the cursor up on that screen so I can click through. There we go. So that's the plan. We'll just run through some IP basics, a couple of things about IP management that are relevant potentially now if you're doing any research or if you've got a job or if you're going to get a job, some things to keep in mind. Happy to be interrupted, and a little bit of a tour de idiocy to help maintain your attention. What's the tour de idiocy? It's some wonderful patent examples, and I'll tell you a bit more about patents, one way to protect your IP. This is one. These are all real patents. They are United States patents because they have the best rubbish patent examples. I call this the toilet snorkel. You can see a guy there. The theory is you're in a burning building, you're in the toilet, you're in the bathroom, there's flames all around you, you can't breathe, but on the wall there's a little box. You punch out the window and you pull out the toilet snorkel, feed it through the toilet into the S-bend and breathe the fresh air and hence survive and probably vomit at the same time. Not really commercial as far as I know. I've never seen one in any public toilet I've been in, but a great example of a US patent that someone's wasted considerable effort and money on. These are all real, minimum 10 grand to get a patent. It's quite old, but still, great example. So you'll get a couple of those if you're starting to fall asleep, just to get your attention back to the front or the slides. So I always like to start with just a couple of quick comments about IP, just to broaden people's thoughts, because IP isn't just some revolutionary invention that's going to make $1 million. It can be a lot of things. And I guess generally speaking, we think about IP a lot more in business because there is a lot more intangible stuff that is adding value to what you do as a business commercially. Back when I was in primary school, they reckon that near on 80% of the value of a business was based on stuff that you could see and touch. So your machines, your buildings, your inventory, that's where the value of your business was. As I was going through uni, the realisation was that there's more of this intangible, clever stuff between people's ears that's really valuable. And now, anywhere from 80 to 90% of the value of a business is probably held in intellectual property, intangible assets that you can't see and touch. All that clever trade secret know-how, IP stuff that somehow allows that business to make money. So if it's so important and it's the major asset part of the business, well, what are you doing to understand it? What are you doing to protect it? What are you doing to exploit it? That's sort of where we help as patent attorneys and IP consultants. Again, IP isn't just that revolutionary invention or breakthrough medical discovery that you're going to make as a researcher. It's a whole bunch of things, and they all add value to a business, and depending on what your business is, some or all of those are going to be more important than others. So even things like your logos, even things like your get-up and your designs on your web page, that's all IP. And if it adds to bringing traffic to you and your business, it's valuable. You need to think about how it should be protected. The other little reminder, I guess I like to make at the beginning, is that very often when we talk about commodity items and products, people often think it's one bit of protection I have to get. I have to get a patent so I can go to market. And more often than not, it's a bunch of rights. It's a little parcel. And this is just a little facetious example. That's an iWatch, obviously. And there's 5 or 6 different forms of registrable and unregistrable IP that cover that device. And that'll very often be the case with anything you're involved in as researchers or in the workplace, whether you're building something or providing a service, whether online or in person. There's probably a number of IP rights that you and the business owners need to think about. And they sort of fall into these 2 buckets: stuff that you have to go and register and often pay for, and other stuff that is free, and often the rights are automatic. And whilst you don't have to know them inside out, it's good to have an idea of what sits where, so that when you spot something within a business, you can raise your hand, you can take it to your line manager or the boss and say, look, I think this is an IP issue, we need to go and ask a deeper question. But we'll step through some of these different rights. We'll pay a little bit more attention to the ones that I guess are most relevant to people in the engineering space, which is where I started as well. Here's another one, just in case you've already fallen asleep. There's no ladies here in person. There might be some online. I don't know if there's any parents, but this is a birthing device. This is a 1950s
birthing assist device. So imagine a centrifuge, you know, the size of your dining table in the birthing suite at the hospital, and you strap your wife, your partner, down onto it in the throes of labour, and then you flick the switch and the centrifuge spins around, and it helps with the egress of the baby out into a capture net between the lady's feet. It's quite a horrible invention, but again, a real invention, a real patent that someone spent money on. Not very commercial, because again, I don't remember seeing one in the birthing suite at St John when we were there with our 3 kids. But someone thought that might be a good idea and went on and patented it. A husband and wife team, before anyone thinks this was just a bloke mucking around, that poor wife. Okay, so some of the basics about some of the IP rights, and I'm going to move pretty quick, but if you do have any questions, just jump in. I like to start with patents. I also promised that you might see Miss Australia, and there she is, Michelle Knowles, Miss Australia 1973, standing there with my old boss, Ralph Tony Sarich. I used to work for the Orbital Engine Company, one of the most prolific patent filers in Western Australia, which is how I got my job. I was the in-house IP manager and looked after a suite of about 1,500 patents and patent applications. No other reason for that picture being there, it's just a cool picture. They're holding the Orbital engine, that 1970s design engine that Ralph came up with. Hopefully you can see something slightly at fault with that image. A fairly slender, small man and a fairly petite lady holding an engine, which probably weighs about 40 kilos, or it should, because that's a plastic mould. Otherwise, I think their knees would be bending, and there's probably a few other people required in that photo. Anyway, patents. What do you get with patents? You get the highest form of protection possible, because you get coverage for how something functions, how it works, often irrespective of size, materials, colours, shape, configuration. So if you can get a patent on a device and protect its function, and someone comes up with something that looks completely different, is a completely different size, made of completely different materials, but it does the same function that you've got coverage for, they report to you. You can enforce your patent, you can ask for a license fee, you can take people to court. But that strong right that you get with a patent comes at a cost. It's probably the most expensive form of IP protection in terms of being able to secure it. The process is rigorous. Examination is compared across the globe. If it's been done somewhere else in the world, you can't get a patent. It needs to be novel, it needs to have industrial applicability, and it needs to be inventive in the eyes of an examiner. And all of those are hurdles to you getting spurious, broad coverage. And the examiner's job is to rein you into what your invention really is solving, what's important about it. They have a finite life, typically 20 years in most countries, and you pay for that benefit annually. Once the thing's granted, you have to keep renewing it. It's not just I got it and I can do what I like for 20 years. And the longer you keep it, the higher the renewals. So the governments are typically saying, we're giving you a monopoly, but for the benefit of our people in our country, we'd like you to put it to use sooner. So the renewal fees are generally less in the early days and follow a bit of a hockey stick curve up into those 18th, 19th and 20th years. You can patent things like apparatus, machines, things that have got bits that move and whir and tick. You can patent methods and methodologies for doing something. At Orbital, lots of methods for controlling how an engine works, those methods being implemented in an ECU with code and firmware sitting behind those. Treatments for different diseases, treatments to do different things for humans, and systems, a system for managing whatever, the flow of data, a system for managing the transport of ore. Very broad scope what you can get coverage for with a patent. I'm not going to run through the different procedures apart from putting them up to show you that there are procedures. There is rigour involved. You've got to file, you've got to get some examination happening, you've got to get some acceptance, and then you've got to get the thing granted and keep paying your renewals. That's the typical process in most countries. And you can find this stuff online, and obviously our firm's got lots of information that we can send out if anyone's really interested in what the patent process is. Individual countries, individual patents is the rule. So when you think you've got a revolutionary invention, As well as your own backyard, you might need to think about what other foreign countries you want to get coverage in because you want to do business internationally. And this is sort of what ends up happening. An idea becomes an initial filing, becomes a secondary filing, gets filed across a number of countries, and then eventually, after many, many years, we end up with patents in 1, 2, 3, 4, 5, 10 different countries. And that's for one invention. So if you've got multiple inventions, you've got multiple applications across multiple countries. You can see some of the numbers being chucked in there just for filing, let alone prosecuting and going through examination. It's an expensive, complicated process. It's not the sort of thing you'd embark on yourself and I'll file my own patent. I don't think I've ever seen I'll file my own patent get to the end and be useful. You go and get help. That's the world of the patent attorney. These are legal documents that have to be technical documents that often have to be promotional marketing documents. That's the role that the patent attorney plays. The thing I do like to do, actually before I get there, patents are written in a particular language. If you've ever had the joy of reading one, and you probably will at some point, in engineering you'll be involved in creating something, someone might want a patent at some point. There's different parts of a patent spec, there's a bit of a description, there's a bit of background, and there's a set of legal statements at the end that are called the patent claims. And you can see those ones up there, they're nice and flowery and mysterious because the patent needs to be broad to not limit unnecessarily. So language like, releasably engageable sealing means, lip portion, fluid seals, all of these things, mechanically there'll be, a lid or there'll be a rubber stopper or a spring, but we don't call a spring, we call it a resilient means because we don't want someone to go, ooh, their limitation is that it has to be a spring. We can use a rubber band or an elastomer instead. So you get this flowery language. That's an actual patent claim for something. I'll give you about 15 seconds to read it and see if anyone nods and goes, I reckon I know what that is. It's a very simple device, one that you probably encountered yesterday, you might encounter today, tonight. Anyone, any quick clues? Don't be shy. This is usually where I have prizes to offer, but COVID says I can't bring prizes because they'll have my fingerprints on them. It's a stubby. Okay, all of that crap. This, that, it's got an upper end, an enclosure device, a lip means, sealingly engageable, blah, blah, blah. It's a stubby. That's how a patent is drafted. Nice, broad, flowery, legal language, which is why you don't have a crack yourself. It's the realm of the patent attorney. Get help if you ever get there. If you've got a boss who goes, I don't like the fact that it's expensive, we'll do our own. Just think of that example, all of that to describe that bottle, let alone the fact that there's probably another 15 patent claims that talk about specific features, like the lid having those little ridges on it, like the base having little ridges so that it provides some grip for a surface that it's on, and it goes on. I like dispelling myths because people often think, patents, copyright, I know about that, I've heard of the 10% rule, blah, blah, blah. So I'll knock a few of those myths out, hopefully. The two main ones with patents are that barbecue comment that the big noting researcher or the big noting boss often throws out. We've got a worldwide patent for our widget. And big noting, we're going to take over the world and make lots of money. There is no worldwide patent. Individual patents, individual countries. There is no mechanism to file one patent and cover the globe. There are regional patents for places like Eurasia and Europe, but even those you still require to pick the countries. It's not just you get all of them. And there are different international ways of getting there, ways to preserve your rights while you're going through the process, but at the end of the day, individual rights, individual countries, no worldwide patent. The other one that is a bit of a common misconception is, I've got my patent, I'm free to exploit. And it's actually not the case. A patent gives you a right to exclude. So I've got a patent, no one else can do the thing covered by my patent. But in terms of me heading to market with it, I have to have a think about what's already out there. Are people covering some of the space I need to tread into to even put my patent into practice? I might need to go get some licenses. So it's not an automatic, get a patent, I can go to market. You do need to make sure you've got freedom to operate. And we'll talk about that a little bit later as well. So no, that's my myth busting. And that's just a picture of what you get in Australia after your hard graft and you get your patent granted. You get a nice little, cardboard certificate. Trademarks. Trademarks is the sexy part of IP because we're surrounded by them. Everything we use and touch and eat and buy has a trademark, and we get familiar with these things. And there's lots of different types of trademarks. The main thing to recognise with trademarks is you're getting protection for something which distinguishes your goods or services from those of someone else in the market. That's a trademark. And in the old days when I joined the profession, it was a logo and it was words. Now it's colours, the colour purple for Cadbury chocolate. It's shapes, the Toblerone box or the shape of the Coca-Cola bottle. It's textures, it's movements, it's patterns, it's sounds, it's smells. If you come up with a new perfume and you think it's remarkably different to the 1,000 other perfumes that have gone before, you can theoretically get that registered as a trademark. If people go, oh, I know what that is, that's Chanel number 10. You've got an opportunity to seek protection in the form of a trademark. One up there, hopefully you recognise, the UWA one, a very famous one, been around for a long time. The Omega mark has been on the trademark register since 1906 or something like that. So trademarks, unlike patents, can be held in perpetuity, provided you pay your renewals, and typically, most countries, every 10 years you have to renew. You can keep a trademark on the register, theoretically, indefinitely, and Omega is a great little Australian example of that. You'll see a nice little equation. I thought I'd chuck an equation in, being that we're in the engineering department here. 34G plus 11S equals 45. Can anyone solve that algebraic equation? Probably not. It's a bit spurious. 34 goods and 11 services classes. There are 45 different classes that you can register a trademark in. So you don't just go, my trademark is Apple and I'm going to register it for computers. Or I'm going to register it for everything. You have to say, actually, I'm going to register it in class 9 for computers, and I'm going to register it in class 42 for services, and I'm going to register it in class 16 for paper items that might bear my logo, and so on and so forth. So 34 of the 45 classes relate to goods, and the other 11 relate to services. When you file a trademark, you need to determine where it's going to go. And that's why you get things like, you'll see the example there, Dove and Dove. One for chocolate and one for soap and shampoo. They coexist on the Australian Trademark Register, the same mark, but they're in different classes. And both of those companies have managed to get Dove registered for themselves. Because in the eyes of the Trademark Office, it's unlikely to cause confusion. When I go to the servo, reach down for my Dove chocolate, I don't go, ooh, there's a bar of soap next to that chocolate, also called Dove. I might get that at the same time. You expect to see them in different aisles at the shops. People recognise them as different products. Same brand, different companies, they can coexist. Lots of examples like that on the register. What else can I tell you? The R in the circle. You'll see that on certain goods, and on others you'll see the TM. And they're signifying that one has gone through and got a registration, the R in the circle. Someone's gone through the process, paid the money, been granted that certificate of registration. They have a registered trademark. I can apply R in circle. While I'm doing that, I can apply the TM, or I can apply the TM while I'm using something to identify my goods or services in the market. I don't have to have a registration. I can have an unregistered trademark. And I can indicate that by putting a TM next to it. The other reason you often see TM is because, like patents, trademarks, country by country, so you can't just get some global trademark registration that covers everything. And if you're doing business cross-border and you've got a registration in Australia and Singapore, but you haven't got one in New Zealand and Papua New Guinea, and your goods are going to all those countries, you probably don't want to put the R in the circle on. Because so far as Papua New Guinea and New Zealand would be concerned, you'd be making a fraudulent claim that you've got a registered trademark right. So often what companies do cross-border when they're working with many countries is they just put the TM. What else is up there that I can quickly tell you about? Bobcat's a really good example. I'm sure everyone knows what a bobcat is. I'm sure people think they've seen a bobcat. Do you reckon you've seen a bobcat? Because you've probably seen a Yamaha or a Kubota or a Case. Okay, they're skid steer loaders is what they are. Bobcat happens to be a very well-known brand, but it's a trademark. It's an identifier that belongs to a company, a US enterprise, who writes to people that manufacture skid steer loaders to say, don't call your skid steer loader a Bobcat in your promotional materials and on your website. That is our trademark, that is our brand, it is proprietary to us. And the reason they do that is if they don't, that term Bobcat eventually will become generic and they'll lose those rights. And there's a litany of examples throughout history, things like escalator and elevator and things that nearly escaped like biro and wind cheater and Ugg boot and you name it. You know, they just got so common in parlance that people just started using them generically. Hoover the floor. Google it. You know, you shouldn't Google it, you should do a search using the Google search engine. So all of these companies try to retain their rights by not letting them get genericised, which is flattering but bad. You don't want to lose those rights. Again, that's the process in Australia. There is some rigour. You've got to file. You've got to be tested against everything that's gone before. You can't get registrations for things that are descriptive. So if something's black, every time you make it, you're probably not going to get black as part of your trademark. You know, black lounges, black leather lounges. If that's what I make, that's a really hard trademark to get because it's entirely descriptive. And other people manufacturing lounges, often which are black, should be able to use the terms black and leather and lounge freely. So you need to have something that is capable of distinguishing that isn't descriptive. That's often where a lot of trademark applications fall down. And I've said renewal after every 10 years. Here's the myth busting. These are the common ones we get. I've registered my business name. No need to ask me about my trademark, Mr. IP person. I've registered my business name. We've secured the domain name, Mr. IP person. No need to ask me about my trademark. Well, actually I do, because they have nothing to do with registering a trademark. Whilst you would think getting a business name gives you some right to the brand, it doesn't. And whilst you would think registering a domain name gives you some right to the brand, that's the first part of that domain, it doesn't. It's a separate registration system and you need to think about all those three in unison when you're starting a company, picking a brand for your product or picking a brand for your business. Just the way it is. And a lot of people come unstuck, particularly with a business name registration. That's merely a listing, you know, in alphabetical order held by some state government department about who's registered their business, you know, ABC Proprietary Limited, who the owner is, what their trading address is. Nothing to do with people being able to use the brand. Oh yes, another one of these. So, something by some dude called Armstrong. I don't know what this is, but you can see the person, you know, cranks a handle when they do that. Some device kicks them in the butt. I don't know, some sort of motivational device for the unruly employee or the difficult student at university. Again, someone spent good money getting this patent granted, you know, a couple of years ago or 2 decades ago. Never seen one anywhere, don't know that I would use it, but clearly someone in America thought that'd be a really good thing. Okay, registered designs. Unlike patents, registered designs give you protection for what something looks like, its shape, its configuration, irrespective of its functionality. Remember the difference. Patents, how it works, how it functions. Registered designs, how it looks, how it's shaped. So, facetious example, there's a chair in front of me. If I was the first person in the world to invent a chair, a device which takes a person's weight, it has a supporting bit for the back and the bum, it's got some legs that engage the floor. If I had a patent for that chair, and some unscrupulous inventor, competitor, let's call them Delucia, said, what a great invention, I'm going to come up with a version of that. I'm going to have a round base and a triangular back, and I'm going to have a rotating bit and 5 legs. If I've got a patent and it's written properly, I don't care. Function, still the same. We have a chat about infringement and paying me royalties. If I had a design registration on my chair, what I get protection for is what my chair looks like. Square back, square bum bit, 4 legs. Unscrupulous rival, 5 legs, triangular back, round bottom. Hey, doing the same job, looks completely different. That's the limitation of the registered design. It protects what it looks like. So if you have something that happens to be Lego or an aluminium extrusion or golf balls or tyre tread, where the shape is inherent with how the thing works, really good value with registered designs. Repeating two-dimensional patterns as well. If you want to take this wonderful flowery pattern that you see here and apply it to blankets and carpet and curtains and t-shirts, you can get a registered design for that. So a lot of people think, what a waste of time. If it's something that's going to have no protection for function, useless. But there are certain products where it has value. Finite life, it's tested internationally, so you can't get a registered design in Australia if it's been done in South Africa. The process in Australia is you get 5 years and then you get a further 5 years with a renewal, and then it's open slather for everyone. So they have a finite life. And the process is quite easier than some of the others. What they've done with registered designs is taken the examination phase and plonked it at the back end. So now you can file a registered design application, provided it meets certain minimum requirements. The drawings are clear, we know who the owner is. Stamp, here's your design, number 1, 2, 3, 4, 5. If you want to potentially license or take action with it, you go back to the designs office and say, can I now have it examined and get my registered design certified? And then you have a certified registered design, which is something that is actionable and that you can sue people with. But because not a lot of that was happening, about a decade ago, I guess, or a bit more, they said, you know what, let's take the examination bit out and put it at the back, because most people never get that far. The myth busting for registered designs, the classic, you only have to change it by 10%. That chair, you only have to change it by 10% to get around the registered design. Not true. There is no 10, 20, 50%. There is no number you have to change something by. In each case, it's just a qualitative and quantitative analysis of what else is out there in that space and how close you are to those or how different you are. There is no 10% change. And limited access, so they only give limited protection, so useless, not worth the paper they're written on. Look, sometimes that's true, depending on what you're in. But if you're building certain items, engineering items, let's pick a ECU housing that's got a particular shape where a wiring loom plugs in, and you're getting that thing manufactured overseas and importing it back into Australia. If the shape is unique enough that you can get a registered design for it, what it means is that if your supplier or people who are in cahoots with your supplier think, beauty, let's rip that off, let's have a cheaper version and let's flick that into Australia, circumvent this person and what they're trying to do, a registered design at least stops them copying it identically. Where they get a hold of your engineering drawings or where they get a hold of your product and reverse engineer some engineering drawings that are likely to be the same, a registered design at least means they have to do something creative themselves to make it look different. And often that's enough for them to go, you know what, I'll go copy someone else's thing. So in that scenario where you're importing certain items that can be protected and you think they might be copied because of what they are, simple products, enclosures, toys, whatever they might be, registered design, quite cheap compared to patents, something to think about, because at least it forces someone to stop doing what they're doing. Copyright. Copyright is really out of the realm of the patent attorney. I'm a patent and trademark attorney. I'm not a lawyer. I'll explain at the end how we get the word attorney in our name. Copyright is something that lives around us. We're always talking about it, but it really is the realm of the IP lawyer. What you get with copyright is protection for how something is reduced to form, irrespective of what it does or what it says, how it's reduced to form. So written documents, paintings, sculptures, movies, photos, software, dramatic acts, plays, all protected by copyright. Typically, and it varies, and this is the realm of the lawyer, but 70 years after the death of the creator is the length of the protection. Protection is automatic. I could right now pick up that pen and paper, look over at Delucia, do a little doodle on my pad, draw what I think is a nice caricature, and I immediately have copyright protection in that. I can put the little notation at the bottom to alert people to that. See in the circle, copyright 2021, Albert Ferroloro. But I don't have to do that to get my copyright rights. They just subsist automatically. No registration process. Some countries you can register, but it's more about damages and making sure that if there is copying, the damages are easier to get. The US is one of those countries. But it's an automatic right. But again, you're not getting protection for function. So if I write some code that's going to drive a spaceship that's going to fly me to the moon, and I write a little side note about how I'm going to build my spaceship, if someone copies those notes, photocopy photo, they breach my copyright. If someone gets wind of what I'm doing, wow, Albert's building a spaceship to go to the moon, he's got some clever code, and they replicate that themselves, and they do the same thing that I'm doing, copyright doesn't give me any protection. Okay, it doesn't protect the idea. It doesn't protect the function, the solution, the recipe, whatever it might be. It protects the written form, the visual form. And that's what you get with copyright protection. So very often we hear bosses going, oh, the patent system's too rigorous, too costly, too long. We're just going to rely on our copyright rights. Well, that's great if you're an architectural firm or if you're a photographer, where everything you do is protected by copyright. But if you're an engineer and you're coming up with clever stuff, clever ideas, it's just protecting how it's reduced to form. It's not protecting the content, the idea, the theory. The myth busting for copyright. Again, you only have to change it by 10% and copyright's not relevant. There is no 10%, there is no 20%, there's no percent. Again, what is it being compared to? What's the issue? What copying has taken place? A judge will ultimately decide. That panpipe riff in the Men at Work song, Come From a Land Down Under, whatever that's called, went to court because it had the panpipe riff that sounded amazingly like Kookaburra Sits in the Old Gum Tree, which the Girl Guides had rights to. Much less than 10% of the song, that panpipe riff, but quite distinct. Distinct enough that there was a court case and ultimately an out-of-court settlement because there was a breach of copyright. So there is no 10% change it by this much and we'll get around it. Just be careful. The other be careful is everything's on the net these days, particularly images, data, graphs, plots, information, formulas. If you go onto someone's website, nick something and pop it into your report or your paper or your business plan, whatever it might be, you've effectively breached someone's copyright. Just because it's on the internet and you can freely see it doesn't mean that it's not protected by copyright, doesn't mean you can freely use it. Go and read the website. What does it say about copyright? If they say you can give me attribution, I'm happy for you to use my pictures, at least you know what the situation is. But generally speaking, every time you grab a photo, a graph, whack it into your report, you're breaching copyright. Reality is, no one probably will find out, and if they do, they don't care. But if you're a firm and you've got a competitor and you borrow their stuff and you erode their market share, or you start making money at their expense using their photos or information, someone's going to come knocking at your door. So be very careful about just grabbing stuff without checking out what the rules are, asking to be sure, or giving attribution or something like that. Trade secrets. Again, the freebie, the one that everyone, patent's too expensive, let's just use trade secrets, they're all free. They are absolutely free. What's a trade secret? It's a secret. Confidential information. How long does it last? How long can you keep a secret? If you can keep it from being reverse engineered and no one finds out what it is, subsists forever. The Coca-Cola formula, secret product X that no one knows, even though people have got science kits that can probably work out what it is these days. They could have patented that formulation for Coca-Cola, 20 years life. Right now it'd be out there because everyone can read the patent and work out what it was. They chose to go trade secret. And they probably did have a trade secret for a while. Now it's just marketing and spin, I would suggest, like the Colonel's 11 herbs and spices. That's a big, valuable trade secret, but really, anyone that's got a bit of a science kit will work out, it's salt and fat and sugar and some other crap. But it's become a bit of a brand, a bit of like a myth, and they play on that. But if it is a real trade secret, And it might be a formulation, it might be some data, it might be a recipe, it might be a flow sheet, it might be a process for doing something. If you can keep that a secret and people can't find out because they can't get a hold of the product or they just can't reverse engineer it, sure, trade secret is there, gives you some protection. Doesn't protect against reverse engineering. So if I say I'm going to protect my black leather chair that I was talking about, that's a dumb one. As soon as I sell it, it's out there. It's not a secret anymore, and if people can look at it and how it works, that's a stupid trade secret. If they can reverse engineer it, if they can independently discover, trade secret doesn't prevent that. But if you can keep a secret, if you've got a business where you lock it down and say only the boss and this person know what that secret powder is that we put in our formulation for whatever our goo is, WD-40, Listerine, they used to be trade secrets, then you've got something. And just the others, very quickly, domain names, park yourself, get a spot. Oh yes, question, sorry.
With the trade secret one, if someone were to discover your secret by malicious means,
Yep.
are you protected?
If there's some fiduciary obligation and someone's broken that, so if I'm an employee and I've taken the secret and gone and sold it to a competitor, doesn't stop the trade secret getting out there, but it does give you means to, attack that individual or the company they've gone to. But yeah, you need to know who it is, what they've done, and you've got to go through the court process and work out they had some obligation and they breached it. Often that's tough to do. Yeah. Just the catch-alls at the end. Domain names, we want to reserve those spots so we can park our websites and things. They're just something that you have to do, a form of IP, I guess. Circuit layout rights, a good one for engineering students, particularly Sparkies. So PCBs, the layout of the tracks and diodes, resistors and what else, transistors that are on those. That layout is protected in the way that copyright gives you protection. No one can grab that PCB and replicate it and rip off what you've done in laying it out in a particular way. And that's the notation you often see on PCBs off in one corner or on the back. It's a form of copyright. But again, if someone grabs your PCB, works out what it's doing and replicates its function with their own PCB, with different tracks and a different layout of bits and pieces, they don't infringe your circuit layout rights. But at least it stops someone doing a blatant copy. That PCB manufacturer flicking your PCB design to someone else in the same space. These things are there to prevent that sort of thing happening. Plant breeders' rights in that sort of space where there's flowers and potatoes and apples and you're coming up with a better strain of wheat that's resistant to weeds or whatever. Plant breeders' rights, it's sort of like a patent, a little bit more involved, won't go into it too much. And common law, lots of common law rights around not being able to copy someone get up and go and leverage their goodwill for your own benefit at their expense. There's common law rights. You typically have to go to court to prove those out, but they're out there and they exist. I'm not going for time. Cool. In case I've lost you, here's another one of these. This is a really old one, 1882 patent. Everyone was looking for a better mousetrap, even in 1882. And there it is. You put your Winchester on some sort of rig and you rig it up with a little lever activator and the mouse comes out of his hole and gets blown apart by your Winchester. Not the best mousetrap, but a really interesting and intriguing image because I still don't know how you trigger that thing. It's like they need to push on it with their paw or something, I don't know. Real patent, by the way. Okay, just some quick comments about IP management. So when you do get into business or if you're in research, some good little things to remember that will keep you from coming unstuck in terms of intellectual property. How do you know if you've got IP? There's lots of ways. If people are asking you about what you've done, can we have a copy? It's making you money. You're having to employ lots of clever people. They're obvious signs that there's, the business or the research is IP rich. But the real easy one is that equation there. There was a problem. We now have a solution. That means you've got some IP, whatever the problem was. And it might be enough for you to raise your hand and go, you know what, no one's doing this way. Maybe boss or partner or whoever, we should go talk to someone about can we get this protected. Just remember that simple formula.
It's one that I try and use with engineers every time I go into businesses. Engineers and scientists have a bad habit of setting the bar really high for what they think is innovation or invention. It was just good chemistry, it was good science, it was good engineering. I didn't think it was important. And the bar's way up here. All they need to be thinking out is, someone gave me a problem, I solved it, the company now has some IP. Up to the company to determine how commercially significant that IP is, but we've got to try and get that bar down, particularly engineers and scientists I find very dismissive. It's just what I do, I'm a good engineer. Think about that formula. Lots of benefits of capturing IP. Often when you start collaborating with entities that are either funding or giving you premises or working together to go to market, there'll be a discussion about background IP, foreground IP, different rights for this new stuff that gets created versus what you're bringing to the table. So by capturing and acknowledging what your IP is as you go into that business, it's easy to have the discussion and say, right, this is what we're bringing to the table. It's codified. This is our background IP, rather than it just being mysterious. Mysterious is bad, because at some point someone's going to ask the question. Even at the end, you know, you're selling out, you're doing your little sale, that's the end point. There'll be some due diligence and they'll say, well, what have you got? What's this IP stuff? So having it codified is great. People move around a lot, and often when they move, they take stuff. And often they set up against you, or they go to another company and use your stuff, your clever ideas. It's easy to have the difficult discussion about, hang on, Bill, that was our code that you've taken over to your rival mobile app developer. And here it is. Here's our IP register. Here's some invention disclosure documents dated. Here's your employment contract that says all the IP is ours. This is the benefit of being proactive in that IP space, thinking about what people are creating and capturing and codifying. Yeah, having an IP asset register, you know, like I say, at some point when you start doing business with others, you can bring that to bear and say, look, we can charge a higher price because when you work with us, you get access to, you know, this list of 34 different ideas, not just our one patent filing that we've got. And it's an easier discussion to have if it's real and it's codified in a register, line items in an Excel table or a Word table. And if you're going to do R&D tax claims, everyone's going to do R&D at some point. Having an IP asset register, inventions codified, experiments captured in some, you know, lab notebook, they all really help that process. The R&D tax advisors love it. IP comes from a lot of places. And often people forget that there's externals that are involved in the process. There's consultants and collaborators, there's students and there's researchers and leads. We've got suppliers and customers, and at different points, depending on what's going on, they might all have some contribution or have something to say about the IP that leads to a final product. Who owns that IP? The general rule of thumb is the person that created it. So if there's no agreement that says otherwise, and you've had some consultant in to do something clever for you, like write your code, like build your app or build your website, if the agreement that you've got in place with them says nothing about IP, the clever stuff in that design resides with the creator. That's my general rule of thumb. So make sure that there's some chain of entitlement, there's an assignment, there's a reference to IP in the service contract that says you're going to come up with clever stuff, that clever stuff will be assigned to us. And if the person wants to charge more because of that, oh, you're going to own my IP, hey, that's great. Have the discussion up front rather than after you've become successful and you're making squillions and then someone's putting their hand up going, hang on, I was the code writer for that. They're now Facebook. I'll have a piece of that action. Get it sorted out early. Get that chain of entitlement, get those assignment documents in place. The myth busting, yeah, we paid for it, so we own it. Or the improvements based on our background IP, so it's our IP. No, no, and no. Whoever creates it typically owns it, unless there's some terms in place that say otherwise. So get the service agreement, get it in place, make sure it says the right things. Yeah, you're paying for a product and you get the work output, but if the product was this particular job and you've then used the same solution over here on your, you know, that's the pilot plant and now this is the real one that Rio's interested in,
That's where you come unstuck. Someone puts their hand up and says, hang on, they're my engineering drawings, or that was my solution for the conveyor. I thought you were just using it on the pilot plant. That's what you paid me for. I didn't realise you're using it on every Rio application in the world. That's where you come unstuck. So make sure that those service agreements say the right thing. Oh yeah, here's another one. God forbid that wearing a pair of glasses with some arms resting on your ears, that's just a pain, isn't it? Having those arms resting on your ears, what a nuisance. Much better to pierce your nose, the bridge of your nose, maybe even through the cartilage. Let's put a hole in there and a little clip, and then we can just clip our glasses onto that clip, and then we don't have to have those annoying arms sitting on our ears. What a great invention. That's much better, isn't it? A hole in the bridge of my nose. How do I quickly remove them is my question. I can see I can flip them up and down, but getting them on and off I think is a little bit more complicated than just taking your glasses off and having the frame sit behind your ears. But again, real patent, real money. Can't say I've seen it in the shop or at OPSM when I go to get my prescription filled. Okay, just a couple of quick ones more. There's lots of free stuff you can do to protect your IP. Just being aware of confidentiality, being aware of your copyright rights, your trademark rights, marking in your publications, in your reports, your website, your apps, anything you come up with, making sure the notation is there, it appears. Using confidential disclosure documents when you swapping ideas, information with third parties. Those developers you want to talk to about providing some help. Don't just go tell them what the secret formula is or what's inside the black box. Get them to sign a non-disclosure agreement so you can have a frank and honest discussion without them running off with it. It doesn't stop people being nasty and stealing your stuff, but it's another barrier in place that makes people think it's something that a judge will look favourably on if you've got one than if you hadn't got one. Little free things that you can do along the way. And be aware of your space, the IP landscape or the IP environment. There's a lot of information out there. If you think that no one's done it before, get someone to give you a little rap across the head because someone's done something similar. And by learning about it, not only do you know what to avoid and not breach someone else's rights, but it might inform your R&D. It might identify customer opportunities or market opportunities. So go and have a look at the IP landscape. Most of us will go into Google and go black box and see what comes up. That's great, do that. But go onto the IP sites as well. There's lots of them, free to use, Boolean operator searching, name searches, really easy to do. The Australian patent search site, this is a 30-second search I did. Typed in, I think, Apple just to see what they've got. Lots of history, who the inventors are, what the invention is. I click through, there's a copy of a specification, drawings, so much information, and that's the Australian site. There's a US equivalent, a European equivalent, a Japanese equivalent. Lots of free information out there. Trademarks, 30-second search, Apple. Going right back, I really don't know about that one, but that's really weird, that first Apple logo. I've never seen it used by them. But anyway, so much information. Often you'll see trademarks getting registered before they hit the market. New sporting teams come out. We already know what they're going to be called because if you watch the trademark search site, you can see people are jumping in and preserving their rights. Lots of information very easily gotten. And again, all the different countries will have an online database that's typically quite easy to use. And the same in the design space. You can see what people are getting design protection for. I've stuck with the Apple theme here. A lot of their tablets and covers and designs for their pods. This is obviously quite old. You can see a lot and you can learn a lot and you can work out what to avoid. Maybe get some ideas to leverage for your own activity.